Hello and welcome to another episode of Your Family Wealth, the show that brings you all things related to wealth protection, wealth planning and wealth transfer. I'm Remy Ayala and I have some exciting topics lined up for you, but first a reminder of the segments for this week's show.
Coming up, the Family Wealth Quiz. Answer at the end of the show. Topic of the week, case history, guest expert, tip of the week.
So what have we got for today? I'll be talking about estate planning around digital assets in topic of the week. And in case of the week, it's another battle of wills, this time between two sisters. And wealth manager Stephen Pitcher will tell us about protecting our pensions. And of course, you mustn't miss my tip of the week. But first, it's that time. It's the Family Wealth Quiz.
What does an executor do? Do they A. manage the estate of someone who has lost mental capacity? B. manage the estate of someone who has died? C. manage the estate of someone who has moved abroad? The answer is coming up at the end of the show.
Digital assets are essentially assets that can be accessed or held online. But there are many types. Online banking, cryptocurrency, payment gateways like PayPal, blogs, ebooks, social media like Facebook, like Instagram. The list is endless and it's all around us. Do they all disappear? This is a real issue for your fiduciaries unless you have done some estate planning. What do I mean by fiduciaries? These are people who manage your estate in the event of mental incapacity or death. And these are people like executors, administrators, attorneys, trustees, or court-appointed deputies. They act in a position of trust, and that's why they're called fiduciaries. The first issue is that your fiduciary might not even know what digital assets you own. If you have managed to keep your gambling habit quiet and under control, how would your fiduciary know that you have an online betting account with £5,000 in it? That's the first issue, identifying your assets. Then when they have identified your assets, how will they access them? How will they know the passwords to the assets? If you haven't let them know, then they won't have access. This is a real problem. And even if they can access them, what rights do they actually own in the assets? Do you just have a license to use the digital asset, or do you actually have any rights in the asset? Many people don't realize that all they have is a license to use certain digital assets. A lot of people spend hundreds, possibly even thousands of pounds adding music to their iTunes account. But is it actually an asset that you own? Well, it turns out you don't actually own the music in your iTunes account. You're only licensing it. That's why Bruce Willis got mad many years ago and wanted to sue Apple, because he wanted to pass his own iTunes account on to his children, but he found he couldn't. The license agreement says that you can't pass your iTunes account on to your children. So just be aware that it doesn't belong to you. Many of you will remember the Charlie Bit My Finger YouTube video, which reportedly earns around $100,000 a year. It has a value. It's important for your executors to be aware of that, as it could be capable of being passed on to the next generation. In this case, Charlie and his brother, the stars of the show. Your email account could also be worth a lot. It could hold evidence of a very valuable contract that would go unproven without the email. If you have a YouTube, Instagram account with 5 million followers, you probably have a lot of intellectual property tied up on your site. The reason you have all those followers is that you've been sharing lots of valuable information that belongs to you, and that information will be lost if your YouTube account should close. Another issue of concern is the sites that shut down after a period of time of not being used, or if periodic payments stop. Loans.com went for $3 million and Funds.com went for $10 million a few years ago. But if you don't pay your domain renewal fee, you lose it. If you lose your mental capacity and your attorney is unaware and doesn't keep up the payments, you could easily lose an asset that's worth a great deal. There is no generalized principle. Each site makes its own rules. But just remember that everything depends on the service agreement you have with that provider. Apple will delete everything once they're notified, and they will only allow access to your executor if they get a court order. You only have a license to listen, and your license terminates on death. That means that if you want to pass your collection on, you need to create accounts on different devices, and you can pass those devices on to your loved ones. But you must make sure that they have the password and that they also keep up the payments, because if you don't pay, you lose it. They won't provide the password or account control to your executors, but they will give them emails on a disk. If you notify them, they will just look to terminate the account. In Japan, there's something called a Yahoo ending, and I hope they will extend it to the rest of the world. They will deactivate an account after death and offer to delete content and also subscriptions linked to the account. They will also send an email which the person would have prepared in advance to up to 200 addresses and open a memorial bulletin board where people can leave online messages. There is a periodic payment for this, so if you don't keep up the payments, then the Yahoo ending may not actually be available when the end comes. Facebook will allow the account to be memorialized, and most people don't know this, but you can actually appoint a legacy contact in advance. That person won't be able to log into your account, but they can add content, for example, to notify friends and family. A lot of us keep digital information in a cloud space somewhere. For those running businesses, a lot of this information is crucial to your business, and it will devastate the business if it were to be lost. iCloud will terminate your account and delete all content. Be warned. PayPal will close the account on the presentation of a death certificate or grant of probate, and they will allow your executors to access the outstanding funds in the account. Keep a digital asset log. Create one where you can leave details of your digital assets for your fiduciaries. You can download one from familywealthuk.com. Prepare written instructions for your fiduciaries to show what you want if you die or lose mental capacity. For instance, do you want your digital footprint to be deleted, or do you want it to be memorialized instead? Do try and read the terms and conditions of key accounts, especially major accounts that can be monetized, like PayPal or cryptocurrency. Finally, when making your will, draft an appropriate clause to give your digital assets away to specific people who you want to inherit them. In addition, consider appointing a specific person that you think particularly suited to the task of managing your digital assets. It should be someone you trust with all the information that will come to light. My final word is just be aware of the issues surrounding digital assets, and be sure to discuss them when working on your estate planning with your professional advisors. It's time now for this week's case history. This week's case is a tale of two sisters, Nikki and Andre, who fought a bitter battle in court over the will of their late mother. Andre accused Nikki of using a drip-drip approach to poison their mother's mind over time against her. Nikki was involved in the making of their mother's will, which cut Andre out completely and left everything to Nikki. The question for the court was whether Nikki had so poisoned their mother's mind by the time she made her will for the court to be able to say that the will was procured by fraud, known in law as fraudulent calumny. So what is fraudulent calumny? Well, it's a situation where a person uses false aspersions to poison the mind of a testator against someone that the testator would ordinarily have made provision for in their will. In this case, Nikki and Andre's mother was known to have wanted to leave her estate equally to both sisters, but Nikki fed her mother stories that Andre had been taking money from her estate. The mother then came to the conclusion that Andre had taken quite enough from her estate and that to equalize things, she would leave the rest of the estate to Nikki. What would the judge make of the allegations? And would the will stand? What can we learn from this case of yet another family destroyed by the expectation of an inheritance? Be sure to watch the rest of Case History right after the show. The link, as always, will be at the end. I have as my guest expert Stephen Pitcher, a wealth manager with St. James's Place Wealth Management. He'll be talking to us today about protecting our pensions. Welcome, Stephen. Thank you for joining me today.
Hello, Remy.
So, Stephen, when a person passes, what happens to their pension fund?
Following the pension freedoms, which commenced in 2015, pension death benefit options have been greatly widened and created opportunities for pensions to be used as a tax-efficient intergenerational planning tool. Your client's pensions can be left to anyone, not just dependents, including family members, financial dependents, or even someone unrelated to them. Under the new rules, the pension funds can be passed on again and again through the generations. This can happen in a very tax-efficient manner without losing the pension tax wrapper until the fund is actually exhausted.
And what can they do to protect the funds from inheritance tax?
The St. James's Place Asset Preservation Trust, also known as a spousal bypass trust, is specifically designed to receive lump sum death benefits from pension schemes and/or death in service arrangements. Whatever your employment status, there's a good chance that there is some form of pension scheme established for your benefit. Now, while these are primarily designed to provide a pension in retirement, they can also provide valuable benefits for your dependents should you die before taking retirement benefits. For obvious practical reasons, you may have chosen for such benefits to be paid to your spouse, civil partner, or partner, as in your survivor. However, the resulting proceeds would then form part of their estate. On the partner's death, this could potentially create or increase a liability to inheritance tax, IHT.
And are there any benefits of the Asset Preservation Trust other than inheritance tax?
In addition, the trust could protect all the beneficiaries from potential divorce claims, long-term care assessments, and creditors.
Sounds like a really useful tip. I believe you have a case study to share with us.
Yes, I have a case study. If we take Barry Jones, married to Linda, and they had 2 adult children. He was employed as an IT consultant and he earned £150,000 a year. He was a member of his company pension scheme, which provided death in service benefits of 4 times his salary of £150,000, i.e. a lump sum of £600,000. Tragically, he was killed in a road accident. He had nominated his wife to receive the death in service benefits from the company pension scheme. The trustees of the pension scheme, acting upon his wishes, paid the entire sum to Linda free of IHT. But 18 years later, Linda passed away, leaving everything to her children. The £600,000 originally received had grown in value to £1.1 million. Now, because of her other assets, IHT was payable on the full £1.1 million at 40%. Resulting in a tax liability of £440,000.
So what would have happened if they had used the trust?
This could have been avoided using the Asset Preservation Trust. By expressing a wish to have death in service benefits made payable to the trustees of an Asset Preservation Trust instead of paid directly to Linda, Barry would have ensured that the benefits were not treated as Linda's assets, yet she would still have access to the money held in the trust. This would have meant no IHT on her death, saving £440,000. The children would have been named beneficiaries, yet the proceeds would not have fallen into their estates.
And a final tip to share with our viewers?
Nomination of beneficiaries or expression of wishes forms. It's vitally important that you keep your expression of wishes document held by your pension trustees up to date. In the event of your death, people whom you no longer wish to benefit could still be listed as a beneficiary. Your pension provider, invariably acting as trustee, has little guidance as to whom you wish to benefit from this asset, other than this document. The will is not binding on the pension fund, so keep your expression of wishes up to date. Simply request from the pension trustees either a copy of the existing letter they hold on file for you, which you probably completed when you joined the scheme, or request a new form to ensure your instructions fully reflect your wishes.
Thank you so much for joining me today, Stephen, and helping us to understand how to protect our pension benefits.
You're very welcome, Remy. I hope this helps.
Please read the disclaimer coming up shortly, together with details of how to contact Stephen. Britain is a nation of animal lovers, and the COVID lockdown has made even more of us turn to pets to help us through this difficult period. But have you remembered to make provision for your pet in your will? In law, your pet is considered property, so you should decide who you want to leave your pet to. Think of somebody that will make room for that pet in their home, or a rehoming charity that will come and collect it and look after it till a home is found for it. You can leave money to that charity to say thank you. If you're wondering if you can leave money to your pet, the answer is no. You can't leave money directly to your pet, but you can leave money in trust for the care of your pet. But you don't have to go overboard like Leona Helmsley, whose dog was dubbed the richest dog in the world after receiving a $5 million trust fund. Not surprisingly, this resulted in a huge fight over control of the money after her death. So leave an amount that's appropriate and be sensible, and also leave a letter of wishes to guide the beneficiary of the pet or the trustees of the fund. So my tip of the week is remember to make provision for your pet. Here's the answer to the Family Wealth Quiz. Let's see if you got it right.
What does an executor do? The answer is B. Manage the estate of someone who has died. Hope you got it right.
I'm afraid that's it for this week. Next week, I'll be talking about intellectual property. My guest expert will talk about investments and where you should put your money. So be sure to join me again next time for your weekly dose of family wealth wisdom. Don't forget to subscribe and hit the notification button to be notified when the next episode uploads. Thanks so much for watching.